Rule 6.1 Voluntary pro bono service. Every lawyer has a professional responsibility to provide legal services to those unable to pay. A lawyer should aspire to render at least 50 hours of pro bono publico legal services per year. In fulfilling this responsibility, the lawyer shall, paragraph A, provide a substantial majority of the 50 hours of legal services without fee or expectation thereof fee to 1. Persons of limited means, or 2. Charitable, religious, civic, community, governmental, and educational organizations in matters that are designed primarily to address the needs of persons of limited means. And paragraph B, provide any additional services through 1. Delivery of legal services at no fee or substantially reduced fee to individuals, groups, organizations seeking to secure or protect civil rights, civil liberties, or public rights, or charitable, religious, civic, community, governmental, and educational organizations in matters in furtherance of their organizational purposes, where the payment of standard legal fees would significantly deplete the organization's economic resources or would be otherwise inappropriate. 2. Delivery of legal services at a substantially reduced fee to persons of limited means. Or 3. Participation in activities for improving the law, the legal system, or the legal profession. In addition, a lawyer should voluntarily contribute financial support to organizations that provide legal services to persons of limited means. Rule 6.2 Accepting appointments. A lawyer shall not seek to avoid appointment by a tribunal to represent a person except for good cause, such as, paragraph A, representing the client is likely to result in violation of the rules of professional conduct or other law. B, paragraph B, representing the client is likely to result in an unreasonable financial burden on the lawyer. Or paragraph C, the client or the cause is so repugnant to the lawyer as to be likely to impair the client-lawyer relationship or the lawyer's ability to represent the client. Rule 6.3 Membership in Legal Services Organization. A lawyer may serve as a director, officer, or a member of a legal services organization apart from the law firm in which the lawyer practices, notwithstanding that the organization serves persons having interests adverse to the client of the lawyer. The lawyer shall not knowingly participate in a decision or action of the organization, paragraph A, if participating in the decision or action would be incompatible with the lawyer's obligations to a client under Rule 1.7, or paragraph B, where the decision or action could have a material adverse effect on the representation of a client of the organization whose interests are adverse to a client of the lawyer. Rule 6.4 Law reform activities affecting client interests. A lawyer may serve as a director, officer, or member of an organization involved in reform of the law or its administration, notwithstanding that the reform may affect the interests of a client of the lawyer. When the lawyer knows that the interests of a client may be materially benefited by a decision in which the lawyer participates, the lawyer shall disclose that fact, but need not identify the client. Rule 6.5 Nonprofit and Court Annex Limited Legal Services Programs. Paragraph A. A lawyer who, under the auspices of a program sponsored by a nonprofit organization or court, provides short-term limited legal services to a client without expectation by either the lawyer or the client that the lawyer will provide continuing representation in the matter. 1 is subject to Rules 1.7 and 1.9a, only if the lawyer knows that the representation of the client involves a conflict of interest, and 2 is subject to Rule 1.10, only if the lawyer knows that another lawyer associated with the lawyer in the law firm is disqualified by Rule 1.7 or 1.9a with respect to the matter. Paragraph B, except as provided in paragraph A2, Rule 1.10 is inapplicable to a representation governed by this rule. Rule 7.1 Communications concerning a lawyer's services. A lawyer shall not make a false or misleading communication about a lawyer's or other services. A communication is false or misleading if it contains a material representation of fact or law, or omits a fact necessary to make the statement considered as a whole not materially misleading. Rule 7.2 Communications concerning a lawyer's services. Specific rules. Paragraph A. A lawyer may communicate information regarding the lawyer's services through any media. Paragraph B. A lawyer shall not compensate, give, or promise anything of value to a person for recommending the lawyer's services, except that a lawyer may 1. Pay the reasonable costs of advertisements or communications permitted by this rule. 2. Pay the usual charges of a legal service plan or a not-for-profit or qualified lawyer referral service. 3. Pay for a law practice in accordance with Rule 1.17. 4. Refer clients to another lawyer or a non-lawyer professional pursuant to an agreement not otherwise prohibited under these rules that provides for the other person to refer clients or customers to the lawyer. If 1. The reciprocal referral agreement is not exclusive, and 2. The client is informed of the existence and nature of the agreement. 5. Give nominal gifts as an expression of appreciation that are neither intended nor reasonably expected to be a form of compensation for recommending a lawyer's services. Paragraph C. A lawyer shall not state or imply that a lawyer is certified as a specialist in a particular field of law unless 1. That lawyer has been certified as a specialist by an organization that has been approved by an appropriate authority of the state or the District of Columbia or U.S. territory, or that has been accredited by the American Bar Association. 2. The name of the certifying organization is clearly identified in the communication. Paragraph D. Any communication made under this rule must include the name of and contact information of at least one lawyer or law firm responsible for its content. Rule 7.3. Solicitation of clients. Paragraph A. Solicitation or solicit denotes a communication initiated by or on behalf of a lawyer or law firm that is directed to a specific person the lawyer knows or reasonably should know needs legal services in a particular matter and that offers to provide, or reasonably can be understood as offering to provide, legal services for that matter. Paragraph B. A lawyer shall not solicit professional employment by live person-to-person contact when a significant motive for the lawyer's doing so is the lawyer's or law firm's pecuniary gain, unless the contact is with a 1. Lawyer, 2. Person who has a family, close personal or business or professional relationship with the lawyer or law firm, or 3. Person who routinely uses for business purposes the type of legal services offered by the lawyer. Paragraph C. A lawyer shall not solicit professional employment even when not otherwise prohibited by paragraph B if 1. The target of the solicitation has made known to the lawyer a desire not to be solicited by the lawyer, or 2. The solicitation involves coercion, duress, or harassment. Paragraph D. This rule does not prohibit communications authorized by law or ordered by a court or other tribunal. Paragraph E. Notwithstanding the prohibitions in this rule, a lawyer may participate with a prepaid or group legal service plan operated by an organization not owned or directed by the lawyer that uses live person-to-person contact to enroll members or sell subscriptions for the plan from persons who are not known to need legal services in a particular matter covered by the plan. Rule 7.6. Political contributions to obtain legal engagements or appointments by judges. A lawyer or law firm shall not accept a government legal engagement or an appointment by a judge if the lawyer or law firm makes a political contribution or solicits political contributions for the purpose of obtaining or being considered for that type of legal engagement or appointment. Rule 8.1. Bar admission and disciplinary matters. An applicant for admission to the bar or a lawyer in connection with the bar admission application or in connection with a disciplinary matter shall not, paragraph A, knowingly make a false statement of material fact, or paragraph B, fail to disclose a fact necessary to correct a misapprehension known by the person to have arisen in the matter, or knowingly fail to respond to a lawful demand for information from an admissions or disciplinary authority, except that this rule does not require disclosure of information otherwise protected by Rule 1.6. Rule 8.2. Judicial and legal officials. Paragraph A. A lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, adjudicatory officer, or public legal officer, or of a candidate for election or appointment to judicial or legal office. Paragraph B. A lawyer who is a candidate for judicial office shall comply with the applicable provisions of the Code of Judicial Conduct. Rule 8.3, Reporting Professional Misconduct. Paragraph A. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, shall inform the appropriate professional authority. Paragraph B. A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority. Paragraph C. This rule does not require disclosure of information otherwise protected by Rule 1.6 or information gained by a lawyer or judge while participating in an approved lawyer's assistance program. Rule 8.4, Misconduct. It is professional misconduct for a lawyer to, paragraph A, violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another. Paragraph B, it is professional misconduct for a lawyer to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Paragraph C, it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Paragraph D, it is professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. Paragraph E, it's professional misconduct for a lawyer to state or imply an ability to influence improperly a government agency or official or to achieve results by means that violate the rules of professional conduct or other law. Paragraph F, is professional misconduct for a lawyer to knowingly assist a judge or judicial officer in conduct that is in violation of applicable rules of judicial conduct or other law. Paragraph G, it's professional misconduct for a lawyer to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law. This paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from representation in accordance with Rule 1.16. This paragraph does not preclude legitimate advice or advocacy consistent with these rules. Rule 8.5, Disciplinary Authority, Choice of Law. Paragraph A, Disciplinary Authority. A lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. A lawyer not admitted in this jurisdiction is also subject to the disciplinary authority of this jurisdiction if the lawyer provides or offers to provide any legal services in this jurisdiction. A lawyer may be subject to the disciplinary authority of both this jurisdiction and another jurisdiction for the same conduct. Paragraph B, Choice of Law. In any exercise of the disciplinary authority of this jurisdiction, the rules of professional conduct to be applied shall be as follows. 1. For conduct in connection with a matter pending before a tribunal, the rules of the jurisdiction in which the tribunal sits, unless the rules of tribunal provide otherwise. And 2. For any other conduct, the rules of the jurisdiction in which the lawyer's conduct occurred, or if the predominant effect of the conduct is in a different jurisdiction, the rules of that jurisdiction shall be applied to the conduct. A lawyer shall not be subject to discipline if the lawyer's conduct conforms to the rules of a jurisdiction in which the lawyer reasonably believes the predominant effect of the lawyer's conduct will occur.